Yes, Mr. Wood.
May it please you, my lords. Before I left the submissions on liberty, I should have stated that in the limited time I won't go into it, but I do adopt the General Legal Counsel's case insofar as it treats with this, commencing approximately, I think, at about page 1927 to 1931 and or 1932, and we also rely on the recent decision out of Trinidad with somewhat similar liberty provision in Attorney General versus Charles, which cited earlier decisions such as Duncan and Jockan, and I think which goes way back to Marage number 2. So we adopt that line of reasoning as applicable to the interpretation of the Jamaican provision. I turn to deal with the provision dealing with search. And again, the treatment of the Court of Appeal in respect of the meaning of search as used in section 13.3J1, adopted Canadian and New Zealand jurisprudence and found it to mean the right to be let alone, which gave protection to privacy of communication. That appears at paragraph 380, page 505. Again, I emphasize that a comparison to Canadian and New Zealand provisions are not applicable given that there is no express protection in those charters for privacy. And also there are differences, substantial differences in wording. The Court of Appeal also failed to appreciate that in the wording of section, that provision in the Jamaica Charter, protection from search is limited to search of person and property. And that is an important limitation that was addressed in the decision of this board in a Bahamian case dealing with the Bahamian Constitution in New Bold versus the Commissioner of Police of Bahamas. That appears at page 4310, and we rely on the paragraphs 24 to 26 at 4325 to 4326. Like the Jamaican provision, the Bahamian Constitution tied search to the person or property, and similarly, somewhat similarly to Jamaica, there was an express protection for privacy of correspondence in Article 23 of that Constitution. And there the board found that those features pointed to the fact that the provision in the Bahamian Constitution should not be as broadly as that of Canada. That case involved the intercept of telephone communications under Bahamian Act, and they found that the interference with the right was that of the right to correspondence under Article 23 of Bahamas, not the provision dealing with search, which was tied to property or person. A paragraph 24, Lord Mann stated, there is therefore some powerful material. This is a page to support the view that Article 21 of the Bahamian Constitution should be given a generous interpretation. That is after reference to the Canadian cases such as Duarte. Nevertheless, the board doubts whether it would be right to treat it as going so far. This is not just because the language of Article 21 is confined to search of personal property and entry on premises. It is partly because Article 23 in the board's view covers the present type of interception, see below, and also because of the history of Article 21 speaks against a broad interpretation. They go into the history. Article 21 reproduces Article 7 of the 1962 Constitution, but Article 7 marked a radical and unquestionably deliberate change from a broad protection of privacy rights, privacy interests. Article 7(1) of the previous Constitution read, "Every person shall be entitled to respect for his private and family life and his home." It therefore echoed most of Article 8 of the European Convention on Human Rights, which had indeed applied in the Bahamas prior to the independence in 1963. Two matters are noticeable. First, even Article 7(1) of the 1963 Constitution omitted the final words of Article 8, European Convention, and his correspondence. So although Article 8 clearly covers interception of conversations, it is far from clear that their interception was intended to be covered even by Article 7(1) of the 1963 Constitution. Secondly, and more importantly, Article 7(1) of the 1969 Constitution, now Article 21 of the 1973 Constitution, were deliberately restricted to physical subject matter. The drafters must have determined to move away from the evidently broader protection afforded by Article 8 European Convention and its partial homologue in Article 7(1) of the 1963 Constitution. That this was a deliberate intention formed because of the wording of Article 7 of the 1963 Constitution was considered particularly vague and general is in fact confirmed by researches into the constitutional drafting process in January 1969 undertaken in the National Archives in Kew by the respondent subsequent to the year before the board. For these reasons, the board is not persuaded that it would be right to interpret Article 21 as covering interceptions of the type presently in issue. The board turns to Article 23. Some of the arguments favoring a narrow construction of Article 21 also have a bearing here. It may be said that the exclusion from Article 7 of the 1963 Constitution and the words and its correspondence and the switch to physically focus Article 7(1) of the 1969 Constitution militate against interpreting Article 9(1) of the 1969 Constitution, Article 23(1) of the 1973 Constitution as wide enough to cover interception of either mail or telephone conversation. But it is also possible that the drafters, when framing these limited provisions, were aware that other provisions might occupy some of the ground excluded. Article 23 of the 1973 Constitution is in terms which reproduce exactly wording found in Article 9 of both 1969 and before it the 1963 Constitutions. This wording precludes hindering without consent of any person in his enjoyment of his freedom of expression, and freedom of expression includes freedom to receive and impart ideas and information without interference, and freedom from interference with his correspondence. It can be argued that someone whose mail is skillfully opened, read, and closed, or whose telephone is skillfully tapped in each case so that he is unaware of what has happened, has not been hindered in the enjoyment of his freedom of expression. At most, the privacy of his communications has been disturbed in a way about which he may subsequently learn and be upset or concerned. The board does not consider that the boundaries between privacy and freedom of expression can be so neatly drawn. The very efficacy of electronic surveillance is such that it has potential, if left unregulated, to annihilate any expectation that our communications will remain private. Justice Forrest in Duarte. But by the same token, human enjoyment and willingness to express our freedom of expression by receiving and imparting ideas and information will certainly be hindered and so interfered with if we are conscious that anything we write or say may be the subject of unregulated surveillance. The more difficult to detect that surveillance is at the time, the more inhibiting its effect. Accordingly, the board considers that interception of telephone conversations falls within the concept of interference with correspondence within Article 23 and its predecessors. Now, I believe it is here to say that similarly the Jamaican provision at section 13J1 ties protection from search to person or property and gives separate protection, wide and separate protection for private and family life, privacy of the home, privacy of other property, and privacy of communication. That's in limbs 2 and 3. This is a clear indication that the Jamaican protection from search was not intended to be as broad, and it need not be as broad as Canada and New Zealand, and that there is separate protection for multiple privacy rights, including privacy of communication. Importantly, my Lord, when you look at the full court's decision, this difference was appreciated by the full court, which noted that the right to privacy in Canada falls under the protection from unreasonable search and seizures, whereas the right was given express protection in section 13(3)J 2 and 3, which protects the right to make private and autonomous decisions. And I take you to paragraph 224, page 196 of the full court's decision. Is it? I think that might be 225. Sorry, that's 225. In testing, the full court stated.
Sorry,
testing,
where are we?
I'm at page 196 of the bundle, looking at what the full court said.
Thank you.
They refer to Regina versus Teslin is Canadian authority for the proposition that the protection of an individual from unreasonable searches and seizures by virtue of Section 8 of the Canadian Charter provides constitutional protection to the right to privacy. It is only in this provision that the right to privacy is reflected in the Canadian Charter. So here the full court appreciates a point that was not taken on board at all by the Court of Appeal. They go on. In Jamaica, the constitutional right to privacy of private life and communication are expressly stated in sections 3J, 2 and 3, and are therefore discrete and distinct from the search and seizure provisions of section 13(3)J1 of the Charter. This is a reflection of the significance of these rights. In fact, section 13(3)J protects the right to make private and autonomous decisions, which includes the right to choose whether to communicate information in one's possession to another. And if I take you over to paragraph 229, they did find that these rights are interfered with. They state, where they begin at 228, POCA has imposed disclosure obligations on attorneys which take away their free choice. It requires them to reveal information about their clients, thus interfering with their right to decide the information to be revealed. At 229, they go on, attorneys are now compelled to report suspicious transactions, to record and disclose information to the second defendant, including the obligation to file declarations, see section 5(3)C of the Legal Profession Act, and to make records obtained and retained available to the designated authority. And the implication of this new duty to make and maintain records, Regulation 618, and to make them available for inspection for at least 7 years, and to make them available to the state if required without doubt interferes with the duty of confidentiality, resulting in an infringement to his right to privacy. And they conclude that paragraph 232, having again cited Duarte at page 198, the first defendant, following the European decisions in Michaud and the opinion of the Advocate General in Polaris Maduro, a ruling consistent with Michaud, tacitly conceded that the requirement for attorneys to make suspicious transactions can be considered an infringement of Section 13(3)J of the Constitution, insofar as it protects privacy of communication. The first defendant, therefore, took the view that there is a need to consider whether the infringement is demonstrably justified in a free and democratic society. They took a similar view with respect to the rights at 234 to 236 again. So, my lords, I submit that the drafters of the Constitution, this is where I begin, because I'm proceeding to look at Poker shortly, but the drafters of the Constitution clearly saw a distinction between a search of the person and property and interference with the person's privacy. Clearly, it is submitted that a search is more intrusive than an interference with privacy, although it would encompass an interference with privacy. And this was discussed in the case of Fisheries case from Canada in Regina versus Leahy. And we rely there on that discussion, which appears at page 6161 to 6162. That was a case where a fishing boat.
Where are you looking at?
I'm now at 6162, my lord, Leahy.
What page? 61.
61. 6161.
Oh, 6161.
Oh.
Leahy. Right.
That was a case in which a fishing boat was stopped for an inspection, and it was held that it did not amount to a search. And the court in that case cited an earlier case at paragraph 21 on 6161 of Wilcox, and stated that held that the mere fact that a fishery officer may suspect an individual of non-compliance does not convert a valid inspection into unreasonable search within the meaning of Section 8 of the Charter. The court stated the nature of an inspection as provided for by Section 49 is less intrusive than a forcible entry and search, and such an inspection generally carries with it neither the stigma nor the more draconian consequences of a criminal investigation. The inspection occurs in the course of participation in a highly regulated industry. The business character of the documents gives rise to a lower expectation of privacy. Finally, the inspection in issue here occurred on business premises where reasonable expectations of privacy are generally low. Taking all these factors into account, I do not accept the proposition that an inspection of business premises in the fisheries context engage the hunter requirement of prior judicial authorization where all officers are investigating a suspect offense but do not have reasonable and probable grounds to obtain a search warrant. No, we submit as to the distinction between a search and a regulatory inspection that firstly, a search is usually conducted to investigate the commission of a crime. Secondly, Judicial authorization by issue of a warrant is required to conduct a search contemplated to investigate the commission of a crime. A search is intrusive, so that where necessary, forcible entry into the person's business or premises is permissible to conduct same. In the absence of such authorization, that search would be either to person or property. A regulatory inspection is less intrusive than a search. Force is not permissible. A regulatory inspection requires the cooperation of the person regulated to permit access to the material to be examined. An inspection in the regulatory context is done to ensure that the business operates in compliance with the rules. And finally, in the context of a regulated profession, there is a lower expectation of privacy. We emphasize that inspections are dissuasive and requires the cooperation of the attorney or other person regulated. Whereas, as commonly understood, a search is carried out by force where necessary and is usually done to gather evidence of the commission of a crime or non-compliance. Now, with that, we turn to the treatment of how the two courts approach the interpretation of the Act and the General Legal Counsel's guidance insofar as it dealt with the regulatory inspections. There was again a divergence between the Court of Appeal and the full court on this. The Court of Appeal found that the full court erred in applying the principle of legality to the interpretation of the Act. And that appears at paragraph 100 and numerous paragraphs, 112 at page 394, 400, paragraph 406 at page 513, and paragraph 410 at page 514. The Court of Appeal appeared to take the view that what we call the principle of legality could only be applied where there was ambiguity or obscurity with the provision. And I stated earlier this morning, they accused the full court of applying that principle to validate the power. It is respectfully submitted that that criticism of the full court's approach was wrong and contrary to well-established case law. In fact, it is a well-established principle of construction that in the absence of express provision or necessary implication to the contrary, the general provisions of a statute are construed on the basis that there was no intention to interfere with fundamental constitutional rights. The cases on that are legion, and it appears, for example, in Aro Ranji versus Cook Islands, the judgment delivered by Lord Newburgh at page 2823 to 2824. And there he stated, a court should, if possible, interpret a statute so that it does not conflict with constitutional limitations. And he referred to Observer Publications Limited versus Matthew. The board has no doubt but that the first component, that is the principle of statutory interpretation, as Lord Cook said in Observer Publications, legislation should, if possible, be read down to comply with constitutional requirements. And as Baroness Hale said more recently, in interpreting statutory provisions, the board should presume that Parliament intended to legislate for a purpose which is consistent with fundamental rights and not to violate them. The principle appears in Bank Mellat as well, paragraph 55, Bank Mellat versus Her Majesty's Treasury, paragraph 55 at page 336. The Court of Appeal, and this is the point I want to come to, the Court of Appeal failed to appreciate that that principle is fundamental to the understanding of the entire regime as set out in the General Legal Counsel's guidance. The limitation of the regime as stated in the General Legal Counsel's guidance is to the 6 activities specified in the minister's order. And similar orders were made in respect to other designated non-financial institutions, such as accountants, real estate agents, so it was because of that the guidance, which was adopted by the minister and issued by Gazette, relied on cases such as Baru Francophones, which appears at 578, which dealt with the application of the European directive, which extended the FATF regime to attorneys in Europe. And in that case, the European Court applied that principle of legality to limit the activities strictly to financial activities. And this is what the full court meant, whether the activities were in a relevant legal context. It's limited strictly to non-legal activities, similar to what a financial institution would do, accountant would do, or a real estate agent would do. So at 578, of the Francophones case, page 5788,
5788.
paragraph 27,
Just give me a moment. 5788.
paragraph 27, they stated, it must first be observed that the second paragraph of Article 6.3, Directive 91/308, may lend itself to several interpretations and consequently the precise extent of the obligations of information and cooperation, I emphasize those words, I'm coming back to it, and cooperation incumbent on lawyers is not entirely unambiguous. On that point, the court has consistently held that if the wording of a second community law is open to more than one interpretation, preference should be given to the interpretation which renders the provision consistent with the EC treaty, rather than to the interpretation which lends to it being incompatible with the treaty. And it's like EC Commission versus EC Council, Spain versus EC Commission. Member states must not only interpret their national law in a manner consistent with the community law, but also to make sure they do not rely on an interpretation of wording of secondary legislation which would be in conflict with the fundamental rights protected by the legal community order or with other general principles of community law. And in that case, they were concerned with whether the extension of the regime was conflicted with Article 6 of the European Convention. And what the court ultimately found is that on that strict construction limited to the 6 activities, it did not engage the conduct of attorneys when involved in the administration of justice or in giving legal advice. And this is what the full court meant when they examined the 6 activities dealt with by the minister. That line of interpretation, and these decisions were relied on and found their way into paragraph 15 of the General Legal Counsel's guidance. That interpretation was followed in a decision of the English Court of Appeal in Bowman versus Fells. Which dealt with the interpretation of Section 328 of the United Kingdom Proceeds of Crime Act, which is in all material or most material respects similar to Section 93 of the Jamaican Act. And I should add that the Jamaican Act is patterned of the 2002 United Kingdom Act. And there the court discussed the principles of legality again at paragraph 78 to 82, page 3640 to 3642. Cited cases such as Morgan Grenfell and Ex parte Sims. And what they found was that the provision for disclosure in Section 328 of the United Kingdom Act did not and was not intended to apply to the activities of lawyers in the ordinary conduct of litigation. In that case, a solicitor became concerned by what he discovered in disclosure and was concerned that the opposing party was engaged in a scheme to defraud tax. And the question was raised whether a report should be made. And the Court of Appeal found that that provision did not apply to the activities of lawyers in the conduct of litigation, and they expressly disapproved dicta to the contrary stated in an earlier case of P versus P. They also found that it did not override legal professional privilege, even though legal professional privilege was not mentioned in that section. That's at paragraph 86, page 3643. And finally, they found that even if the solicitors began activities coming within the regime, which flowed into legal proceedings, then the regime ceased to apply to him. That's at paragraphs 89 to 90, 3644. And it is that line of authority that informed what you see at paragraph 15 of the Council's guidance. That's at page 7095.
Give me that again,
7095. Where it is expressly stated that the regime is not applicable to attorneys when engaged in legal proceedings or in giving legal advice. It says, as a general rule, participation in litigation and other forms of dispute resolution by an attorney and the giving of legal advice are not professional activities coming within the DF&I order. Activities carried on by an attorney in the normal course of litigation will not be within the DF&I order. Similarly, where litigation results in the order of a court for payment, transfer, or distribution of money, property, or assets, or for the regulation, management, or winding up of a company or other entity, the attorney's continued participation in such a transaction will not come within the ambit of the DF&I order. I repeat the first line. As a general rule, participation in litigation and other forms of dispute resolution and the giving of legal advice do not come within the order. So, I come to this, my Lord. A question was asked of my friend as to whether the full court unduly confined legal professional privilege, and I take you to a relevant legal context. And I submit that they did not. I take you to, I begin at paragraph 124, where in our Justice Sykes, that's at page 157 of the record. Justice Sykes, in granting the initial order, had queried what was the situation where Johnny in Kingston asked Grandpa for a loan to pay down on a house, and Grandpa comes to the lawyer for advice. And Justice Sykes queried, where are the boundaries? And at paragraph 124, page 157, the full court answered it very clearly. In relation to the example cited by Justice Sykes, in such a situation, privilege would indeed apply, as Grandpa has prima facie sought legal advice. The appropriate assessment in this context is whether the communication was within a relevant legal context. In the material questions The material questions are, does the advice have a relevant legal context? Does the advice relate to rights, liabilities, obligations, or remedies of the client, either under private or public law? See Ballabel versus Air India discussed in the foregoing. The boundaries are then delineated by privileged circumstances, the relevant legal context. So the court clearly treated seeking and giving legal advice as a relevant legal context that is not within the regime. They then go on, it therefore follows that as Grandpa was requesting legal advice, his communication to his attorney would be subject to legal advice privilege, and the attorney would not be acting in a purely transactional relationship and would be wearing his legal spectacles. See Three Rivers, number 6. It is difficult to see how the attorney could be classified as being involved in the transaction itself, when all he did was to offer legal advice to Grandpa, acting in his traditional role as attorney. They go on at 125, page 158. Whether applying the test in Ballabel or the expanded test outlined in Commerce Commission versus Bay of Plenty Electricity Wellington Registry, it is apparent that in general, the specified regulated activities of lawyers designated as DFNIs fall outside the ambit of LPP. There is, in the circumstances of these activities, generally no advice that would be required that relates to rights, liabilities, obligations, or remedies in the realm of private or public law. That is to be understood because these are the same activities that are designated for other professionals, accountants and real estate agents. The activities are devoid of the concept of the administration of justice and are activities the performance of which are also enjoyed by other groups. If the relevant legal context materializes during a transaction and the nature of the relationship changes to include legal advice, it attracts LPP and would be exempt from disclosure under the regime, unless, of course, it falls under the intention to further criminal purpose in the Act. And to similar vein is at paragraph 131, page 160. In relation to the activities in the order, our useful and rudimentary test is the one suggested in Three Rivers number 6, which asks whether a lawyer would need to wear his legal spectacles to advise on the matter in question. If the answer is no, there would be no relevant legal context and privilege would not apply. The concept of LPP has been and remains closely tied to the administration of justice and the duty of an attorney to the court. There will be no privilege if a communication is between a lawyer and a client for purely business and or financial related transactions. So the full court is quite clear that once it engages legal advice, it is within a relevant legal context and the regime is not applicable to that.
Can I just ask you in relation to that, goes back to a question my Lord Briggs asked this morning. If you instruct your attorney in relation to the purchase of a property, won't it necessarily involve some giving of legal advice and providing of information for the purpose?
And that advice is protected by LPP.
Just the advice?
The advice, yes.
But not the provision of information?
Again, that would depend on the circumstances. If the information is given for the purposes of seeking advice, it would be. And Ballabel, I think, casts a fairly wide net on that, which is addressed in the full court's judgment, that there is a continuum
yes,
which would be protected.
But won't that cover most cases of selling and purchasing properties?
It may cover the correspondence, but it would not cover the transactional documents itself.
No. I see that. What about the drafts?
It may cover the drafts.
Yes.
And the essence of the inspection regime is that it leaves the attorney the scope to take advice on this and to remove those documents from the inspection process. Where the General Legal Counsel seeks an inspection, it would not know what documents you have. It would not know who your clients are. It would not know what transactions you engage in. The General Legal Counsel gives you prior notice that we need an inspection. You have 14 days, and the guidance at paragraph 18 then says it is incumbent on the attorney to remove what he considers to be privilege from the files that will be available for inspection. We will know what he removes. And that ultimately, I submit, is what led the full court to say that the interference with privilege is negligible, because this is entirely in the hands of the attorney, who ought to be acquainted with privilege and the principles of privilege, to sort out his files and to say what is available for inspection. This is not, and I'm coming to that, this is not a search where the General Legal Counsel, like the police, forces itself through the door and trolls through the attorney's business and files. That was never the intent, and that I respectfully submit is not the power given by the Act. So if it's a regulatory inspection, as we say, then privilege is protected because it is in the hands of the attorney, who is the guardian of the client's privilege, to remove that material. And that's his professional duty.
Can we just look at the relevant provisions of the Act?
It's 91A, my lord.
So 2290.
Oh, when you go to section 91A, well, there was some question as to what was the role of the General Legal Counsel if it's a criminal investigator, and I suggest that on an interpretation of the Act is untenable. Section 91G, which is at page 2289, tells you that the competent authority means the authority from time to time authorized in writing by the minister to monitor compliance by any type of business in the regulated sector with the requirements of this part and any regulations made under this part, and 2, issue guidelines to the businesses in the regulated sector. And this comes under part 5 of the Act, whereas there are powers for search and seizure in part 6 under criminal investigation. Section 91A at page 2290 sets out the principal functions or the objective, which is in addition to any other functions of a competent authority under this part and without prejudice to any other functions which that competent authority may exercise under any other enactment, a competent authority shall exercise the functions set out in subsection 2 for the purpose of ensuring that any business in the regulated sector which the competent authority is responsible for monitoring operates in compliance with this Act and any regulations made thereunder. So it's regulatory compliance is the primary objective of the powers that Subsection 2A says, a competent authority shall establish such measures as it thinks fit, including carrying out or directing a third party to carry out such inspections or verification procedures as may be necessary.
I'm sorry, which page are you actually on now?
2291.
Yes, thank you.
It leaves it to the competent authority to establish such measures as it thinks fit, including carrying out or directing a third party to carry out such inspections or such verification procedures as may be necessary. That section does not state what the measures are. It leaves it to the competent authority to establish the measures. The measures can include inspections or other verifications as may be necessary. That is a discretionary enabling power. It does not state that the competent authority has the power to enter, search, and seize property in anybody's premises. The principles of legality do not compel such an interpretation. There is no power of entry given. It leaves it to the competent authority to establish the measures. If I am correct that that is an enabling power, that does not set out the details of how the competent authority should carry out its inspections, it does not set out that or dictate that the competent authority should establish measures to enter, search, and seize, then there is no basis to strike down this power if the competent authority should have developed procedures or guidelines that amount to a search and seizure. You may attack the guidelines if it amounts to a search and seizure, but it's certainly not a basis to strike out this general enabling power, which simply allows you to monitor compliance by establishing such measures for inspection or verification as you deem necessary. And the Court of Appeal has struck down the entire inspection regime on the basis that it considers that the guidelines did not spell out adequate protective measures regarding search and seizure.
May I just ask, so let's suppose a competent authority did wish to establish measures in terms of carrying out or directing third parties to carry out an inspection. How would that particular authority get the relevant sanction that it needs, the relevant legislative sanction that it needs to carry out that inspection?
I believe that this will be wide enough to enable the authority to do so by issuing regulations, because it says shall establish measures. And there is also a provision where it goes as far as to enabling the licensing of businesses, if that is required. That is at subparagraph 6.
And what is the extent of the inspections that can be carried out under this envelope?
I go back to the Francophones case. The inspections that can be carried out are regulatory inspections, which, like any other inspection, requires the cooperation of the person regulated. It requires the cooperation of the person to allow you, if that is necessary, to enter the premises. It requires the cooperation of the person to allow you access to the material to be inspected. If the person does not allow that, you cannot force it. You then need to go to some other sanction. But you cannot go like the police, kick down the man's door and rifle through his material at will. That is not, I submit, permitted by this. And these general provisions, I submit, need to be read in the context of the constitutional protections in Section 30.
Might it require the person in charge of the premises to permit you to enter?
It would. And we have cited a case where that the court formulated that as a basis for the Anton Pillar order. It requires the person's permission. And in the reasoning of Lord Denning, that cooperative measure avoided the problem of the entry being a trespass. So that is precisely how the General Legal Counsel understood this, and that's precisely how it formulated its guidelines, which I will come to in due course.
So the same applied to C, examination?
The same would apply to C. Right. To examine and tape copies, again, cannot be effected by force or compulsion. It requires the cooperation of the person regulated to allow you to inspect, examine, and to take the copy of what you have examined.
It might be thought to be a rather direct way of expressing the rather more limited power that you're advocating.
Well, I believe, my Lord, that that is the only way to read the power in the absence of express provision to give a right of entry.
Yeah.
If you don't have an express right of entry, it can't be effected except by way of cooperation, allowing the person access, the inspector access to the material.
Or court order.
Or a court order.
Well, it's cooperation backed with the automatic commission of a criminal offence if you don't cooperate.
Well, again,
under subsection 5.
Yes. But again, if you read again, the reason of the Anton Pillar is that the failure to cooperate may result in sanctions, but it still is not done by compulsion or force.
I think the regime here in relation to regulation of solicitors is parallel to this, so that the regulator, the law society, is entitled to require production of documents and so on. And if there's a failure, then it can apply to court to get an order. If the premises are locked and empty, including knocking down the door and going in.
With a court order.
With a court order.
With a court order.
Could you help me, while we're on this section? I'm looking at the sharing provision in subsection 2D. Maybe you're coming to this.
Yes, I am.
Well, when you do, I found what a competent authority is, and I found what a designated authority is, but I can't find what a supervisory authority is.
The supervisory authority would be the Bank of Jamaica or the FID or the Financial Services Commission. These are bodies, I believe. My understanding of their role is that they relay, for example, where persons are listed under the UN orders regarding terrorism financing, and they issue these orders. So they have a broader jurisdiction. The point that I want generally to note about these provisions is that there is protection, express protection given for privilege at section 91A3, which says nothing in subsection 2C shall be construed as requiring an attorney to disclose any information or advice that is subject to legal protection.
And the person
You will see.
I beg your pardon, if the person who's permitted entry by somebody who's left in charge of the premises finds documents, and some of them may be privileged, what's that person meant to do? Assess them and then put them on one side, or?
He would assess them because this would be supervised. The General Legal Counsel had this supervised by an attorney, or if it comes to the hands of the General Legal Counsel, it remains privileged. There is some dicta in, I think, B and Auckland Buildings District Council on that with Lord Millett. In that case, you will recall privileged documents were issued to the Auckland District Law Society on conditions, and when the attorney called back for the documents, they refused to hand it back, and the Privy Council held in that case that the documents remain privileged. There was a famous statement by the board, Lord Millett, that the cat remains a cat. If you let it out of the bag, you can put it back in. So the documents remain privileged. And one should bear in mind that the General Legal Counsel is this statutory regulator for attorneys who are bound to observe and required to monitor the observance by attorneys of proper ethical standards. So if a document that is privileged comes to the hands of the General Legal Counsel, one would expect, as they said in the B. Auckland case, that would be respected. The General Legal Counsel, after all, is composed by a representative of the Chief Justice, a representative of the Attorney General, the Minister of Justice, and 14 attorneys. If that body can't administer and respect privilege, then it brings into question their right to regulate ethical standards by the profession. I put it straight as that. They should understand these rules, and I think it is fair to say that one should assume that they will comply with it. There is a similar submission that yes. The fourth, in relation to who is the supervisory authority, this is named in the fourth schedule of the Act. Page 2355 at paragraph 2.
Thank you.
Page 2355.
The Bank of Jamaica and the Financial Services Commission. What I think is to be remarked upon in the Court of Appeals decision is that they utilize a provision such as Section 92A3, which
Section 92.
A3, which says nothing in subsection 2 shall be construed as requiring an attorney at law to disclose any information or advice that is subject to legal professional privilege. And how the Court of Appeal used those provisions is to say that evidence that privilege is at risk by the regime. So they took the very protective provision and found that privilege is at risk.
Could you just give me the paragraph number of the Court of Appeal? Where they say that?
Paragraph 219 to 221, page 442 to 443.
Thank you.
Paragraph 271 at page 465. And with respect to the sharing of information, paragraph 550 at 571. That question about the sharing of information is particularly interested because that stated that the competent authority, that's at page 2291, in the exercise of its functions may share information pertaining to any examination conducted by it under this section with another competent authority, a supervisory authority or a designated authority, or an authority in another jurisdiction exercising functions analogous to those of any of the aforementioned authorities. 1, other than information which is protected from disclosure under this Act or any other Act or any other law. 2, subject to any terms, conditions, or undertakings they think fit in order to prevent disclosure of the kind referred to in subparagraph 1 and secure against compromising or obstruction of any investigation in relation to an offense under this part or any other law. And the Court of Appeal treated that provision, particularly subparagraph 1, which is protecting information that should not be disclosed under the Act or any other law, as itself evidencing that there is a risk to privilege. If I turn to paragraph 550,
Paragraph 550.
Yeah.
550. That begins at page 571. This is how they treated with that provision I just read. The fact that above that they said, furthermore, clients to whom a duty of confidentiality is owed would not reasonably expect that information they disclose within that legally protected context would someday reach the hands of a foreign state. The fact that this is possible and foreseeable is evidenced in the provisions of section 91A2D2, which stipulates that the GLC may enter into an arrangement including undertakings, getting undertakings from, with specified third-party state agents, including agents of foreign states, concerning disclosure of privileged information. This would suggest that Parliament had in its contemplation that privileged as well as non-privileged information may reach the hands of the GLC and be shared with foreign states upon proper arrangement made by the GLC to prevent disclosure. 1, it is in their hands, once it is in their hands. So they take, in my respectful submission, the exact opposite interpretation of that provision, which says that you can't share information protected from disclosure under this Act or any other law, as evidencing that there is a risk that the GLC will share privileged information.
So your submission, it could not, be, under any circumstances, be shared with foreign states
It could not be.
upon any arrangement being made?
No, it could not be. And in my respectful submission, all that information, all that provision is saying is that we know that there are professionals who straddle multiple professions. You have a lawyer who may be a real estate agent, or you may have a lawyer who practices in Jamaica and also practices in a foreign country. And for the proper regulation of that attorney in respect of those activities, there may require some amount of sharing of information to have effective regulation. And shall I go to, where am I? The section 137, there is an amendment to the Act at section 137A. Can I find it? If I can locate that, I'm a bit off now. Where the Proceeds of Crime Act was amended to require competent authorities to compile statistical information for sharing with designated authorities, the Director of Public Prosecutions. And that act, that amendment expressly states that client confidential information such as the names of the clients can't be shared.
Is it somewhere in the bundle?
That amendment appears at page 2389 of the bundle. It says an entity designated as a supervisory authority, competent authority, or designated authority shall keep such statistical records as it considers appropriate for the purpose of measuring the overall effectiveness of measures. The minister may by order, publish in the Gazette, specify entities other than those specified in subsection 1 that are required to keep statistics. And subsection 3 says, statistical information kept under this subsection may be disclosed to any entity referred to in subsection 4 if the information does not include any information from which the identity of any person or other personal details in respect of any person is ascertainable either on the face of disclosure or by reasonable inference. And the entities they name include the Director of Public Prosecutions and the designated authority, which is the Chief Technical Director of the Financial Investigations Unit. Now, I suggest that statistical information that the competent authority compiles could only be taken out of the examinations, the inspections that it carries out. And it would be absurd if, in compiling the statistics, the Act precludes you from sharing personal details, but then you can go directly, willy-nilly, and share it under subsection 91A. So there has to be a limitation on the sharing, which is only necessary for the effective carrying out of the regulatory process and would not, as a general rule, entail the sharing of confidential information.
So this relates to statistical information.
Statistical.
You're saying a similar limitations to be applied into
Section 91.
Would it?
AD. Because, as I say, 91D includes among the persons to whom information is shared under 91A, D is the supervisory authority, the designated authority, which is the chief technical director, named in section 137A. So if you can't share in that way, there is, as a general rule, I would suggest that you are precluded from sharing it in the form of the examination information unless it is necessary to carry out your regulatory functions.
Are not the lists of persons in section 137A 4 quite different from the sharees in 91A? Just whizzing back to the section.
Find the definition.
2288, I think.
No,
because hold on. I'm in trouble getting back to it.
the chief technical director named in 137A is the designated authority named in 91(2)D.
Can you just give me the reference to 91A again? You get a page number.
2291.
2291.
But this information can be shared with authorities from other jurisdictions.
Again, the objective is effective regulation, and again, it would require an assessment to dictate that some amount of sharing is required for effective regulation. I give the example of the attorney who practices in multiple jurisdictions.
So perhaps could just remind us, a competent authority is what?
The competent authority is the body responsible for monitoring compliance of the person in the regulated sector and for issuing guidelines under Section 94.
I see, yes. And the supervisory authority, I think,
is the Bank of Jamaica and the Financial Services Commission. They are named in the 4th schedule.
and a designated.
And the designated authority is defined in Section 91(1)H as meaning the Chief Technical Director of the Financial Investigations Division of the Ministry.
The point of, well, one of the purposes of sharing this information is to enable crime or alleged crime to be investigated.
No. Well, yes, that may be one.
That goes well beyond regulation of the profession.
Again, the objective is to monitor compliance. But one cannot exclude, and I say this.
In paragraph D, surely that's not really monitoring compliance, is it? I mean, that's enabling the regulator to pass on evidence suggesting a commission of crimes.
I would say that it would not be ruled out if there is a crime that is discovered.
Well, or evidence suggesting the maker.
Or evidence suggesting, because in the same way that the person regulated would have a duty to make a report, I would think that the regulator, again, if a serious crime is suspected, would have a duty to pass on information.
But if that's right, it would be extraordinary if, by this curious process of implication from Section 137A, a sharing under 91A to D could not include any names or anything which would identify a person,
Okay.
or any personal details.
I am, perhaps I'm putting it correctly, I am submitting that the overarching purpose behind the exercise of any of these powers would be the responsible monitoring of compliance of the regulated person.
That's your solution, yes.
And if in the course of that it becomes necessary to engage in some amount of sharing, then subsection D is giving that discretion to the competent authority to do that.
Yes.
With other competent authorities. And what I would,
What does the Chief Technical Director of the Financial Investigations Division actually do?
he investigates crime,
Right. So
financial crime.
he's the sharp end of the
Yes,
financial crime.
he is the investigator of crime.
Right. And therefore, somebody who, having investigated, recommends a prosecution, for example.
Yes.
Yeah.
What I would like to point out, and again rely on in understanding these provisions, is a statement from Suraj versus the Attorney General of paragraph 73, which is at page 6635. And it flows from a point made in our case that the rights and protections given in the Constitution are applicable to public administrators, the executive, and in some cases, even private individuals on Jamaican case law. And what was stated in Suraj is that the rights in Section 4 do not just come into play when legislation is in contemplation, but are general in their application. It seems to the board that it was this dimension of the issue to which Baroness Hale was referring in Surat, paragraph 58, when she observed that the rights were qualified, which may be limited either by general legislation. I'm at 6635.
Yeah, I'm with you now.
Either by general legislation or in the particular case, provided that the limitation pursues a legitimate aim and is proportionate. When any public official, from the president down to an ordinary police officer or social worker, takes action involving an individual, that individual is entitled to require them to respect their fundamental rights under Section 4. So, for example, unless the rights are treated as subject to an inherent proportionality requirement, a social worker could not take a child who is at risk into care against the objections of the parents who say that to do so would infringe their right to respect for family life under Section 4C. Moreover, this example illustrates how individual rights can conflict with executive action, has to be taken just as much as when legislative choices have to be made, since a child's rights to protection under Section 4A, B, and C conflict with those of the parents. As explained above, the rights have to be balanced against each other. In the board's view, the only way in which rights can operate coherently at the level of ordinary executive actions by public officials is if they are interpreted as limited rights, which naturally implies that they are subject to the proportionality qualification. We submit that as a statutory regulator, such as the General Legal Counsel, they would exercise their powers, one would safely say, in keeping with the observance of fundamental rights conferred by the Constitution, and would not by its actions interfere with such rights, save where required to discharge its duties and where demonstrably justified in a free and democratic society. And I submit that a body such as the General Legal Counsel, given its composition, would be well equipped to understand, weigh, and apply that test of reasonableness in coming to a determination or in taking the actions under subsection 2. I would like to go, there is of course a divergence in respect of whether between the Court of Appeal and the full court as to whether the Section 90A2 gave a power of search. The Court of Appeal went so far as to say an entry into the premises is permissible, because it speaks to an inspection. that implication is not supported by the Act, where you will see in Part 6 provisions dealing with investigations, disclosure orders, where there is express provision made for the issue of orders or warrants permitting entry. So, for example, under Part 6,
Can you give us a page, please?
I'm going to page 2311, Section 105. Empowers a judge on application to make a disclosure order where the person is the subject of a money laundering investigation. Section 107, subsection 2 at 2314 specifically provides that where the judge makes a disclosure order, he may, on an application made to him specifying the premises, make an order granting entry to the premises. It is only with such an order that the officer is entitled to the grant of entry. That's at section 107, subsection 3, page 2314. Again, section 108, subsection 1 provides that disclosure order cannot require production of privileged information. That's 23, page 2314. Search and seizure warrants are dealt with at section 115, page 2324. And section 115, subsection 3, specifically provides that the warrant authorizes the person to enter and search the premises and to seize and retain the information found therein. Section 118, subsection 7, which is at page 2329, specifically provides that the person exercises the powers under a warrant can secure assistance from other persons as reasonably necessary to execute the warrant. Given the express provisions dealing with power of entry, I submit that the silence in section 91A, subsection 2, speaks volumes that the right of entry was not intended and cannot be imported by implication.
But under section 91A, a regulated person, say an attorney, can be required to permit entry, can be required to make documents available for inspection, and if he doesn't, can be subject of criminal proceedings and striking off.
Yes.
I mean, is there any difference of substance?
There is a
between
difference
those
in
parts
substance.
which have a pretty compulsive effect on professionals because of the ultimate striking off consequence of non-compliance. And these general powers, which are exercisable against, as I understand it, any member of the public who is thought to be, is properly thought to be the subject of a money laundering investigation.
I submit that the fact that there are sanctions that may be applied does not negate the element that there has to be cooperation in the exercise of the power of inspection, that it cannot be forced onto the attorney in the sense of a search warrant. And again, I made the point that this is a matter of degree. The intrusiveness is a matter of degree. And I don't want the submissions to be understood to say that as found by the full court, there is intrusion into privacy. But I submit that the elements that one would have in a search and seizure as understood in a criminal investigation do not exist in these circumstances, and were not intended in these circumstances. My lords, I turn to consider, and there is a good practical reason, I submit, why the full court was justified in reading this limitation into these powers. These powers apply to all other designated financial institutions and professionals. It applies to the financial institutions such as banks, it applies to insurance companies, it applies to accountants and real estate agents. These professionals also owe duties of confidentiality. So to say that the powers are reprehensible to attorneys because they amount to search and seizure, but it's okay to exercise it in relation to other professionals, I suggest is inconsistent. And the powers have to be read down in the way that I have submitted and in the way that the General Legal Counsel understood that the powers are intended to operate. Not by way of force, a forcible entry, not by way of, as I say, entering somebody's premises and trolling through at will, through their documents, but by cooperation with the regulated person providing access to the material. And again, nothing prevents the designated person from saying, I will provide inspection in another form. I will come to the General Legal Counsel's office with my files, for example. I go on, my lords, to consider the guidelines of the council, which were criticized by the Court of Appeal. And I emphasize the overriding provisions at paragraph 15, 16, and 18, which appear at the bundle at 795, which makes clear that the 7,095, which makes clear that the scope of regime was not applicable to attorneys. And insofar as inspections are engaged, the attorney is given notice and is required, or we suggest, should sort his files and separate out any privileged information. The General Legal Counsel has no prior knowledge of what is going to be inspected. So that again is at the total control of the attorney. Paragraph 54C of the guidance, which is at 7122, expressly advises that in respect of the sharing of information pertaining to any examination of the attorney's business with another competent authority, a supervisory authority, or the FID, it does not include information protected from disclosure by law, such as privileged information.
I'm so sorry, which paragraph are you on?
54.
Thank you.
Subsection C.
Yeah, got it.
7122. Paragraph 48 on 7121 sets out the three types of examination that were contemplated by the council. being a routine biennial examination every 2 years, a follow-up examination, and a random examination. The routine examination is carried out biennially every 2 years by a public accountant who is selected and retained by the attorney. It was contemplated that in that intervening period, the General Legal Counsel would carry out random examinations. The material that the random examination would focus on is set out at paragraph 49 of the guidance. The routine examination that is set out at paragraph 49. And the items set out therein are to test compliance with the obligations in the regulations. And if you look at it, the only client information that is looked at is at H&I, customer due diligence and procedures, including more rigorous requirements for high-risk clients and transactions, the maintenance of records of client identification and verification of identification. That is the requirement of the regulations. And I, maintenance of records of complex or unusual or large transactions or unusual patterns of transactions. The Court of Appeals concern related to random and special examinations. I would ask you to note that at paragraph 217, page 442, the Court of Appeal found that when they looked at the routine examination, they had this to say: on a close review, this at 442, on a close review of the matters which form the focus of the GLC's monitoring functions as set out at paragraph 49 of the GLC guidance, it is apparent that the role intended to be undertaken by the regime would be primarily regulatory, as Mr. Wood submitted. The regulatory role is particularly evident when one focuses attention on the GLC's anti-money laundering examination form provided for in Appendix B of the GLC guidance concerning routine examinations. This role at first glance seems innocuous. Their concern was respect to the other examinations which is an accurate criticism, that the guidance did not explain what these other examinations entailed. And they said that on the same page 442, at paragraph 218, they said, in terms of random examinations, there is nothing disclosed as to what exactly these will entail. The processes and protocols for these examinations are not disclosed, except that prior notice will be given of the intention to inspect them. No form which will be used in those examinations has been made available for scrutiny of the court. Therefore, what is likely to transpire during such examinations remains unknown. There is uncertainty. There is no certainty that claims of LPP could not arise in such situations. The statement that the guidance did not set out in detail what those examinations entail is accurate. It is not accurate to say that no form was made available to the court for scrutiny. And that form, which is Appendix B to the guidance, appears at 7127 to 7132. If you go to the form at 7127, you will see that it is exactly the same form that is used for all examinations. It begins, the purpose of this form, that's the first paragraph, is to assess the level of compliance of attorneys with the Jamaican AML CFT laws and regulatory guidance. Who should complete this form? This form shall be used by the General Legal Counsel and accountants duly authorized to act as agents of the General Legal Counsel to conduct examinations. The next third section says, please indicate the type of examination to be conducted. And it sets out the various examinations that are named in the guidance. There follows information that must be populated in the form. Which could only come from the attorney. Example, part 1, TRN details, that's the tax registration number for the attorney or the firm. The details of the partners, details of other attorneys in the form. Part 2 of the form sets out a series of questions. Are there policies and procedures that characterize facilities into either high or low risk of money laundering, showing the criteria used for such categorization? And it asks to fill out yes or no. If the answer to question 1 is no, the examiner should not proceed with the examination and should immediately notify the General Legal Counsel. Again, the basic purpose of the DFNI is to categorize clients on the basis of risk. So if he has not begun by doing that, it makes no sense to go further as per this form. It then has a number of client files on record, number of high risk, number of low risk, number of client files examined. Has the identity of each client for the files examined been established and verified in accordance with the ML law? What number and percentage of files examined did not comply with question 15? The only information that the form requires to be attached is information as to the training sessions that the staff are required to participate in. That appears at paragraph 22. Is there an internal AMF staff training program in place? Yes or no? If yes, please attach list of sessions, topics, and attendees. Has any staff attended or participated in AML training sessions conducted either locally or abroad? If yes, attach a list, venue, participants, and proof. That's the only information that the form requires to be attached. So as per the comment of the Court of Appeal, the examination is on the face of it innocuous, and although it's not stated specifically in the guidance itself, it certainly was the purpose that this is the examination that would be conducted in all the various forms of the examination stipulated in the guidance. Appendix C to the form, which is at 7133, sets out the form of notification to be given for the random examination, which, as worded, requires at least 14 days notice to be given, and it requests the cooperation of the attorney by stating to facilitate examination, you are asked to make available to the examiner such records, written or electronic, as he or she may require. That is the penultimate paragraph of the form. So, as the powers in section 91A2 have been concretized in the guidance and in the forms, there is certainly no exercise of power evident here by the General Legal Counsel to enter, search, and seize anybody's property. The contemplated inspection is based on, I repeat, cooperation by the attorney as per the Anton Pillar decision, which appears at page 2720 to 2721 of the bundle, a decision of Lord Denning, with whom Mr. Justice Armorad concurred at 2722. I am running out of time, so I won't read that to your lordship. I go to the disclosure obligation in section 94 and 95 of POCA. And the council reviewed this and determined, and we submit, that it is compatible with and does not infringe legal professional privilege. There is express provision at section 94, subsection 5B, which expressly protects privilege. That contrasts with the equivalent of section 328 of the English Act, which is to be found at section 93 of the Jamaican Act, dealing with disclosure as a defense to charge of money laundering. Yes. Disclosure as a defense, where if the person knows or suspects that he is going to engage in a money laundering transaction, he can obtain a defense by making disclosure and seeking the permission from the FID to obtain consent to proceed with the transaction. That provision does not have any express protection for legal professional privilege. The equivalent of that protection, that provision, section 328, was interpreted in Bowman versus Fells, which I dealt with earlier. And they ruled in that case that it has to be implied that LPP is protected. No, if LPP is protected by implication under section 328, and that stands and is applicable to attorneys, and protected by implication, and yet under section 94 and 95, which has express provision protecting LPP, that has been found not to be adequate. And those provisions have been struck down. Again, I submit that makes no sense. The provisions for protection of LPP, particularly by attorneys who should understand the rules, are, I submit, adequate. What I would like to deal with, my lord, in the limited time available, is the change in the rules of LPP that the Court of Appeal effected. The rules of LPP that existed in Jamaica up to the time of the Court of Appeal's decision are the same as the English law of LPP. And we have set that up very carefully in section paragraphs 64 and 65 of the GLC's case, which is at page 1938 to 1939. We have set out the case of RBS rights issue, which deals with the burden and which points out that LPP is unusual because only the client and the attorney has knowledge of it. And this is consistent with a decision of Mr. Justice Sykes in Simmons versus Jamaica Cooperative Credit Union, where he expressly held that the burden of proving LPP lies on the party who asserts it. That case is at 6413 of your bundle.
So you say the definition of the Act reflects Jamaican law?
It reflects Jamaican law. The absence of procedural rules to assert LPP set out in a statute is not a requirement, as we see from a recent decision just endorsed by this board last week in Smalling versus Satterthwaite, where in determining issues of LPP, the judge, when the matter was brought before her, set out the guidelines, judicial guidelines, as to how she would proceed with the matter. So that negates any suggestion that, as in Canada, LPP needs to be legislated. The procedure needs to be legislated. LPP has been developed by the courts, and the courts have consistently set out judicial guidelines as to how they will treat with a dispute. It does not need to be legislated. The problem that occurred in Canada is that in two decisions, Lavallee and the later case of the FLSC, Parliament attempted to legislate the procedure. And the legislation itself was found to breach the constitutional right of liberty. I would ask you to note that in Lavallee, the court pointed out at paragraph 11, page 5084, that provision that was being considered, which was section 4881 of the Canadian Code, had been enacted to protect solicitor-client privilege at the urging of the judiciary, who kept saying, don't leave it to judicial guidelines, Parliament should intervene and regulate this. And it was that regulation that was found to infringe the liberty right for the various reasons given by Lavallee, which included the fact that by the statute, if you didn't claim it within a specific time, you lost it, and the judge had no discretion. So those are the problems that occurred and are illustrated by Lavallee and the FLSC case when there is an attempt to legislate this procedure.
It is, I assume, to a limited extent legislated for, or at least recognised in your civil procedure rules. Provisions governing how you give disclosure of documents in civil litigation.
Yes, yes.
But if it's like our rules, it's very much on the assumption that you know what it means.
It does.
Yes.
Yeah. But again, there is, as seen in cases like the Auckland building, if there are buildings, the district law society, if there's inadvertent disclosure, that's not the end of the matter. You can get it back.
Yeah.
And you can get an injunction to prevent the use. What I want to bring to your lordship at this point is that the law that the Court of Appeal applied in respect to finding that there is a general presumption of privilege that applies to all documents in the attorney's files, as taken from the Canadian case law, is not representative of English or Jamaican law of privilege. It results from an amalgam of French civil law as applied in Quebec, to which they have amalgamated principles of English common law.
Well, you've dealt with that at great length in your written case, Mr. Wright. Mr. Wood, I'm just conscious that we're getting up against the time limit.
But there is a discussion of that, my lord, if you could just note this, in the Foster-Wheeler case, which was applied in that, the Foster-Wheeler was the case applied in the notary's decision. And that discussion of the amalgam of the law of Quebec, which includes a provincial human rights provision, with French law and English common law, appears in Foster-Wheeler at paragraph 18 to 28, page 4281 to 4286.
Thank you.
And what Foster-Wheeler also points out at paragraph 28 to 30 is that a great deal of confusion has occurred given the dual origins of French Quebec law of professional secrecy in the translation of the judgments from French to English, so that there results in confusion as to the terminology of solicitor-client privilege, professional secrecy, and confidentiality, and immunity from disclosure, which they say is all comprehended in the use of the term in their law of professional secrecy. So the Court of Appeal failed to appreciate that they were dealing with a jurisdiction where their law is partly civil law and was not applicable to Jamaica. And I submit that because there is some issue as to whether the Court of Appeal could change the law, if the Court of Appeal has elevated, or the Jamaican courts have elevated the legal professional privilege to a constitutional provision under the due process, then the court should not and could not change it in the way that they did if they intended to change it. If it's now a constitutional principle, it can't be changed like that willy-nilly. That has ramifications for numerous laws in Jamaica and also ramifications for legislative powers.
Well, we're up to 4 o'clock. I think we're there.
Could I be allowed 5 minutes in the morning?
Well, you'll have to negotiate it with Mr. Mahfood and have it docked out of your reply time. That's how we deal with it.
I'm obliged.
So I'll leave you to sort that out over the adjournment, and either at 10:30 or 10:35 we will have the pleasure of hearing from Mr. Murphy. And the board will be very happy for you to make.
Or if you could give me 10 minutes to wrap up.
No, don't increase in the time.
No, I'm afraid we do operate to quite strict time limits,
Obliged.
Mr. Wood. Thank you, 10:30.